So Eric McLauchlin with PK Law. I've coordinated a lot, and there's a lot of confusion we have noticed when it comes to estate planning. And usually everyone has good intentions, but sometimes the plan isn't quite what they thought. And so let's go through some of the estate planning 101 items. I'm going to do some rapid fire questions for Eric that we get often from clients, and then we'll, if we have some time, open it up for Q&A. So ask an estate attorney whatever questions you would like without the meter running is kind of what I'm trying to save some time for.
I'm actually billing Joe. He just doesn't know that.
It's not on your dime, so, you know, have at it. Eric, thank you so much for joining us. This is a complicated topic and something that, unfortunately, I think all of us at some point in our lives will probably address with family members and things like that as we age. But jumping right into it, what is the order of operations for estate? Somebody passes, you have, well, I don't want to give you the answers because you're going to share them with us, but how do estates get settled? What are the layers that we look at from one to the next?
Yeah, so you could have answered the question because I think you understand the fundamentals, and most people do, is once somebody has passed, you're going to undertake this exercise of figuring out what is it that that person had and where does it go next. Does it already have instructions on how to get there, or does it not have instructions so that you need to rely on a law or some other resource to get it to that point? Sometimes that's called probate. Right? That is the process that gets used when it's the orphans court that is directing what's happening next. Sometimes it's called administration. That's when you already have a trust or some other document, resource, structure that's telling you this is how it gets from point A to point B. Other times it's because you have things titled or beneficiary designated and have already told them where to go. So fundamentally, it's pausing for a moment, figuring out what that person had or owned, and helping those things get where they're supposed to go next based on instructions that exist or laws that exist.
So hypothetical, let's say I have a will and I am married again, and I want everything to go to my current spouse, but I never changed my beneficiaries on my 401k because I don't really think about it, and I pass away. Would that money from the 401k go through the will, or would it go to the old spouse who's still on the beneficiary because I never got around to changing it?
One of the things that I love about doing presentations as an attorney is that we get to give attorney answers like, it depends, right? And that's what you would expect. Actually, from some lawyers, you would hear, well, what do you want the answer to be, right? But it does depend, right? So if your first spouse had died, then there are fewer complications than there are if you were divorced from your first spouse. If there's a divorce, there's possibly a marital property settlement agreement or a divorce decree that removed the rights of a surviving spouse. But the fundamental question or the point that you're making is that if you've left it that way, if you've left an unchanged beneficiary designation, at a minimum, you're creating confusion. One possibility is that if you've left a wife that's passed away, that beneficiary designation will fail, meaning there is no beneficiary designation. And the result will be that that becomes a probate asset that has to go through this process of being administered through the orphans court to get to where it's supposed to go next. It no longer has instructions. The instructions you gave it failed.
Perfect. So when we're creating an estate plan, well, first question is, how often should we be reviewing our wills and estate documents and making sure that they continue to be in line with our wishes if we're not around?
Great question. What I like to encourage planners to do is to approach planning from the perspective of who is involved, what's involved, what do you want, and who's in place that's going to help make that happen for you. So who's involved, what's involved, what do you want, who's going to make it happen. And the frequency with which you review that depends on, have there been changes in any of those things, right? So if I plan for my brother to be part of my plan, and he passes away, that's a reason for me to make a change, right? I don't want to leave a plan that includes somebody where my who's involved doesn't apply anymore. The same thing with the what's involved. If I have real estate investments that I use as rentals, but I've sold one last year because I want to do something different investment-wise, then my what's involved has changed. The what do I want? Well, if when I planned for my children originally they were 5 and 7, but now they're 22 and 25, what I want for them is substantially different. And then the last one, the who's going to make it happen. The first time I drafted a will for myself, my father was my executor after my wife. Well, he's 83 years old this year, and that's not a burden I want to give to him. He's got plenty of things to work on his own without also having to administer my estate. So that would be a change to make of who's going to make it happen. Who, what do you want? Who's going to help make it happen? If those things change, do it. Otherwise, the truth of the matter is when you sit down with your financial advisor, when you sit down with your accountant and do your taxes each year, or when you do an insurance review, why not go ahead and review your plan at the same time? So if that's an annual thing for you, pause and think about those 4 categories and say, anything different? If not, let it ride. If there's something you're curious about, ask a question.
That's right. Do you ever see an aversion to getting estate documents because people feel that once they actually plan the estate, they feel like the proverbial bus will get them when they walk out of your office?
I do feel like there is this set in stone that causes people to freeze sometimes. And look, was that true at one point? Yes. You've heard of the word codicil, probably, is you have a will. A codicil is really a quick change to a will. The reason those used to happen is because wills were typed out on typewriters using this really thin onion skin paper. And so attorneys didn't want to have somebody in their office. They didn't do it themselves, believe me. They didn't want to have somebody in their office have to retype the whole thing. So let's just do a one-pager. Nowadays, it's all word processing, right? And so we have computers, and the ability to make an update to a plan is so quick and so convenient that I encourage people, it's just too easy to update it. There's no reason to feel frozen about if I put something down now, I'm stuck with it, because nobody's stuck with it.
No. And I think hopefully everyone in this room would not want this process to be overly burdened on those that they leave behind. So a phrase that I really believe strongly in is an ounce of prevention is worth a pound of cure. And if things are not left in an orderly fashion, it leaves a lot of cure for the generation that has to sort through the estate process. So trusts. Trusts are this mythical creature in the financial planning world. People think they're the greatest thing since sliced bread. It's going to save them on taxes. It's going to create a world of opportunities, but that isn't necessarily the case. So, Eric, when are some examples of where trusts really might start to make sense and some where they don't quite fit? It might be a sledgehammer when you only need like a regular one.
And it is, because in my industry in the early 2000s, there was this cottage industry of law firms that would sell a binder of documents and say, you've got to have this trust. You've got to have this so that you can avoid probate, and you've got to do this for tax reasons, and you don't want to have a will, you want to have this instead. And so what happened for us within the 5 or 10 years following that is we get people that come and bring us this binder and they say, I got a plan. And we ask them, well, what did you do to fund your plan? What assets did you put into that trust? Remember, I said it's about things having instructions that tell them where to go next. And if you haven't actually funded your trust with those assets, they had a really pretty binder. It's probably more expensive than what it's worth, but that's not a good reason. Okay, that's my point with that. If you're considering trust or you have curiosities about trust, what I would encourage you to do is think about a person, a purpose, or a process for why I have a trust. and I'll give you examples for each. The person, I'll use my daughters as an example again, 5 and 7. At that age, those are persons who I do not want themselves to inherit wealth without some structure around it. And the ability to put structure around that after I'm gone can only live in a trust, right? So that's a person's. Another person's example would be someone with disabilities or someone who receives public benefits that would be put in jeopardy if they received wealth, if it's means tested. So persons. Purpose. Here's a happier version. Let's assume I have a beach house, a vacation home. And my goal is not only for my daughters to be able to continue to use that into the future, but for their kids and their kids. I want this to be a true legacy. Sometimes we'll create a trust around a specific asset and say, here are the rules for the McLauchlin family beach house. And here's how that's going to happen moving into the future. So you create that vehicle, and you would fund it with that beach house, and then you would let that go. And then the process part is, are there rules around which I want someone to receive wealth or assets? So oftentimes that looks like, again, I'll use children as the example. If I only want them to receive things for education, if I only want them to receive things for health, if I want to make sure that they don't go out and buy a car, right? If I only want them to receive it at certain ages, if process of how they receive it is important to you, the analogy I use is create the tube of toothpaste, right? Put the asset in that, and then you decide how often it gets squeezed to benefit them over time. So persons, processes, those
I'm taking the toothpaste analogy,
Do it.
and I don't know if I'm going to give you credit in a meeting for it.
I
Just
probably
full
stole
disclosure.
it from someone else, but yeah.
So, to piggyback on that, a trust, long-term care policy, an annuity, these are just tools in the toolbox. I don't want to rule out any of the tools, not necessarily that we're going to use them for whatever job. And I'm agnostic. I like annuity like I like a screwdriver. It works if I'm trying to, but if I need a hammer, that's not the right tool. So having access to all the tools available, you can build a better plan or financial house for your future. Trust, another one of the tools. It may work, it may not fit your situation perfectly. Who or how should we think about the person who is the executor of our estate? How do we pick the right person?
The person themselves in an ideal world is someone who would understand finances, but what you really need them to do is have the wisdom to go to the attorney, the accountants, the person who's going to help them through the process of administering what they need to do next. So you said executor. I'll put trustee in that same basket, right? These are persons, you saw the word earlier today, fiduciary. Their job becomes to do things only in the best interests of the persons for whom your plan is designed, okay? And so think about, who would do that for me? What is their skill set is one way to look at that. Are they money-minded or are they not? But the other is, do they know my heart? Do they know my preferences? Do they know the intentions and the reasons I put this here? If I give them a certain amount of discretion to administer the trust or the will that I've set up for the benefit of my daughters, are they someone who has or might develop a relationship with my daughters? On one hand, there can be times when you want that fiduciary to be a dispassionate person. You just want them to follow the rules. But most of the time, it's going to be somebody that's within your circle and somebody that knows you, knows your family, knows your assets, and knows well enough to contact the professionals that are going to make these things happen next.
I see a lot of times clients come in and they're afraid, one, that if I don't have a will or something in place, that the state of Maryland or the government's going to take all of my assets and it won't go to my kids. Is that the case?
It is not the case.
It depends?
It depends, right. So the great news for each of you is that in your folders, I've prepared a will for all of you already. You already have a plan. It's in there. And it's laughy-jokey, and it says the intestate last will and testament. Intestate literally means I don't have a last will and testament. So that's what makes this a joke, right? But what this is, when you're bored later today, and you look at that, this is a set of rules of what Maryland would put in place for you if you didn't have your own plan. And it's things like, the thing you're asking, will the state come in and take it? No, but there is a rule that says if all of the possible instructions that I've included in my will or my failure to have a will, if all of that fails, then there's a possibility that my assets will pass to the Board of Education in the county where I live or to the Department of Health if I didn't have long-term care like Mr. Monahan recommended and the health department had to help provide for my care. So it's only an extreme example of where the state would end up receiving any of your wealth. However, it's an easy example to fall into the trap of allowing the state to provide the rules that would be in your will for you if you don't do it yourself. So why not do it yourself? A classic example has been husbands and wives who assume that if one of them passes, the other automatically gets everything because they're married. And that skips over so many other elements. How are things titled, etc. But it also skips over Maryland law, which has been the wife actually gets 50%. The kids get the other 50%, notwithstanding even what their ages are, notwithstanding whether or not there was a trust. So these are really good reasons to make sure you develop your rules instead of allowing the state to develop those rules for you. There are rules. It's not just going to go to the state, but there's no reason to allow that to happen.
When completing beneficiary paperwork, very often there's two different categories for how you designate a beneficiary. The only Latin I know, it's either per stirpes or per capita, which are two very different things, and it's probably confusing to most people. Can you tell us the difference between how those two paths, one works versus the other?
Yes. Per stirpes is a fancy, schmancy Latin phrase that means keep it flowing down the family tree. So if my father leaves assets to me and to my brother per stirpes, but my brother predeceases and he has kids, then my share would come to me. The share that would have gone to my brother keeps flowing down the family tree on that side. It literally means by the stocks, by the category of people that flow that way. Per capita means literally per capita. You count the heads, and you only distribute to people who are alive and there. So if my father left it to me and my brother per capita, and he predeceases me, I'm the last man standing, everything would come to me.
And if your beneficiary designation says per capita, per head, whoever's left will divvy up what it is, but the will says per stirpes, I would like my grandchildren to get my child share if they're no longer around, which would supersede the other?
Yeah, and that's really important because in the world of identifying where things already have rules that tell them where to go next, a beneficiary designation will control before your will controls. So if something is beneficiary designated and it says, my father beneficiary designates something to me and to my brother, they're going to look, when we administer the estate, we're looking to that beneficiary designation first before we look to my father's will. So in that sense, the answer to your question is it won't matter what the will says. The beneficiary designation is going to control. The exercise that I would encourage all of you to undertake is making sure when you look each year at, or frequently at, who's involved, what do you want, who's doing this, if you see changes that create something that no longer matches with your beneficiary designations, update them. Am I right that it's pretty darn easy to update a beneficiary designation as well?
With e-signature, it takes 2 seconds.
Right. So there really is no excuse not to make sure when I say updating a plan, I don't mean rewriting your will. I mean pausing and reviewing all of those things, because the other part of your plan that you already have, even aside from my laughy jokey will, is if you have a bank account and you titled it somehow, that's part of your plan. The way you title assets is your plan, right? But your will provides instructions for those things as they're titled on where to go next after you're not here. The beneficiary designation is the same thing. It's a massive part of your plan, particularly if you have investments in different vehicles and things like that give you the opportunity to make that decision. Make sure you're doing it.
A common good intention that I see with folks, because our homes, especially lately with the rising housing costs, homes represent a tremendous amount of our net worth. And we, with good intentions, want to make things easier on our children. And I get the question very often, should I put my kid's name on the title of my home so it doesn't go through probate and it's easier for them to inherit? Why, Eric, might not be the best option for a couple with good intentions?
I'll give you 4 primary reasons. And you're right. The intention behind doing that oftentimes sounds like, well, I want my sons to have my house anyway. I'm going to go ahead and put their names on it now, because that is what would happen anyway. One of the things to think about, though, is when would that happen? And the reason to think about the when is if my father leaves a house to me and my brother, at the time that we inherit it, we get what's called a step up in basis, tax basis. You've probably heard of that before. It relates to capital gains. So the idea that there's a value at which we buy things and then you measure that against the value at which you sell things. Well, when I inherit my dad's house, my basis sets at what its value is at the time I inherit it. If my dad adds me on the title now, everybody's basis gets set now. And you may be creating a tax gap there that otherwise you wouldn't have to. If the goal is that the property should pass someday, let it pass someday. Just create the right vehicle for letting that happen. So that's one thing, is tax basis. Another is gifting, right? And it's true that there's a certain amount of gifting that can be done every year without the need to report it to the IRS, and certainly without the need to pay tax. However, if my dad puts me in title on his house, and even assuming a modest value of that house, it's going to be more than what that annual amount is to the IRS. So somebody will have to report that a gift has just been made from my father to me of the value in that house. Not the end of the world, but it's a tax ramification, a tax reporting ramification that you may not have actually intended to have happen. Another is loss of control. Loss of control. And I'll give you an example. I was counseling with a family recently who came to me and they said, well, years ago, Mom created this deed and put all of our names on it, and there are 4 of us. But now Mom has decided, and we have all decided, that sibling number 1 is going to buy the house. Well, okay, that's great. And there was reasons to do that. It generated money for Mom. She needed that to be able to provide for her care, etc. But now, because Mom didn't control it, she didn't have the ability to do that transaction. She had to get the permission of all of her kids. And as life happens, one of her kids is a squirrel. And so it's making the transaction a little bit difficult, all right? And so that loss of control certainly is not why these things are usually done. And last would be creditors, frankly, that when you put someone in title to a piece of real estate, even though they don't own the whole thing, if they own an interest in that asset and they themselves incur a liability, their portion, their ownership interest in the house is exposed to that liability. So that's another reason why we typically advise against it. And we look for other reasons, like what is the goal that was actually being sought at by looking at, I want to do something different with how this is owned.
So the intention is I would like to make an easier process for my kids to inherit it, but with step up in basis, child gets divorced, that spouse could try to claim their portion of parents' primary home. So maybe that's not the route that makes sense for most people. What is a way to accomplish that intention yet still maintain the flexibility and the step up in basis?
The most flexible way to do it, and the thing we do most often, is called a life estate deed, where it would be me taking my house and deeding it from me back to me for the rest of my life, with the remainder, meaning at the point that I'm no longer here, the instructions I have now given in that deed are, it goes to my daughters. So from me to me for life, then to my daughters. But there's a layer that we add on to that. There can be a life estate deed with powers and a life estate deed without powers. Without powers means you reserve no ability to make any changes to that in the future. What I love is a life estate with powers, because it says, I'm doing this, I'm setting these rules up so that I know where this asset's going to go next, but I reserve the right to change my mind. If you're not nice to me at Christmas, I'm changing this deed, right? Or better yet, if I discover that I have a need for funds with which to provide for my care or someone else's care, I might choose to liquidate this asset. And unlike the mother that I mentioned, I won't be inhibited by needing somebody else's permission. It's a life estate deed with powers. It's essentially, the way I would think about it, it's beneficiary designating your house.
Yep.
Or beneficiary designating some other asset or piece of real estate. Yeah.
Most folks I work with, and not for, they like control in terms of not to, exert, but they like controlling their own destiny. Right? Maintaining independence and being in the driver's seat for decision making. Do I own my home and keep it? Do I sell it? I want to be able to make these decisions. Do I want to go to a facility, or do I want in-home care? So creating all this flexibility with adjustments for the future, I think, is probably the better way to go if you share that same sentiment that most people I come across do. What are some other, maybe one or two examples of mistakes you've seen people make with estate planning, or thinking that maybe an estate plan will do something more than it really has the ability to do?
One of the mistakes that I do see often is in thinking that estate planning only relates to what happens when I die. There are tools that we draft that are planning for death, but there are many things that you do that are planning for life. That includes things like an advanced medical directive, where someone helps me in the event of my incapacity with making medical decisions and helping get through a tight spot. The other is a financial power of attorney that does the same thing. If there comes a time when I'm unable to relay or to share information about what I want next, and a fiduciary needs to help me do that, I would rather that happen now than see my family have to undertake a guardianship, which frankly is what would happen when those tools for living are not in place, right? If you don't have the advanced medical directive that's named someone as part of your estate planning, then the solution becomes having to pursue guardianship of the person. And when you don't have the financial power of attorney, the solution becomes having to pursue guardianship of the property. I'd rather people have those documents, because those two processes is not the end of the world, but it's time-consuming, inconvenient, sometimes expensive, and it's an invitation for other people to create conflict over something that you can direct in advance without any conflict being part of the criteria.
So you're telling me that when there's a bunch of money involved, sometimes people get a little squirrely and start to... I'm shocked.
It's interesting, yeah.
Incredible.
Yeah. So the estate planning becomes the things that you layer into your recipe for guac, so that when you mix it up, it doesn't turn into a brown mush. It stays nice and green, and you can pass it on to people without them worrying about what it looks like.
I love it.
Yeah.
Those were some of the quick top questions that we get often, but we were successful in allowing some time for any questions. So while Eric is on my billable hour, does anybody have any estate planning questions? Start in the back.
Yeah, just quickly back to the taxes. What's the best way to avoid inheritance taxes?
I have really good news for you. In Maryland, inheritance tax only applies to non-lineal descendants. So in the examples that I've given, if my father leaves things to me, if I leave things to my children, or even if I'm not here and per stirpes things pass from my father to my children, that's all in the trunk of the family tree. And there is no inheritance tax when we pass things in Maryland to lineal descendants. And believe it or not, even though I don't like my brother that much, if we pass it to siblings as well, there's no tax, okay? Where it would apply is if I leave things to a cousin, to an aunt or uncle, to a nephew, to a friend. These are people that, because they're not in that trunk of the family tree, they will pay a 10% tax. There's not a whole lot that can be done to avoid that going, because believe it or not, that tax even applies if it's passing outside of your will, meaning I can't do something sneaky like, well, I'm not leaving it in my will, I'm just adding your name to that bank account, right? You can't really get away with that because all of those things have to get reported. So the first thing I would recommend is just be mindful of the person to whom it's going and what their relation is to you, because there's this whole category of people that won't be taxed.
What?
In Maryland now, or is it how often do you find it state and nationwide?
I can't speak nationwide, but most of the adjacent states have similar situations where inheritance tax doesn't apply to, they'll find other ways to generate revenue.
So federal estate limits, you're allowed to pass up to a certain amount. And that amount is?
I'm going to argue with you for a second.
Let's do it. I love it.
Yep, and it's my ear, not yours, but it's my fault. But the gentleman's question, if I understood it, was inheritance tax, right? Okay, so here's a way to think about that. Inheritance tax is based on where is the gift going. What you started to address was estate tax. Not inheritance tax, but estate tax. Estate tax is based on what is the value of the gift, regardless of where it's going. What's it worth? Okay? And on that, also good news, that the values that we may now pass to others before estate tax kicks in has gone up and up and up and up and up over time. So presently at the federal level, it's $15 million. That was snuck into the one big beautiful bill, whether you like that legislation or not. That was a hidden piece of it. It's $15 million. Maryland's threshold is $5 million. Okay? And then married couples should think about those things as being able to be stacked. It's called portability. If I don't use mine, my wife can port my $5 million over to her $5 million. So really you're talking about $10 million estates and $30 million estates before estate tax kicks in. Some households deal with that. Fewer and fewer are having to deal with it. Yeah.
I have a question. So my mom is developing, she has a trust now for her descendants, and I'm the only one that's still alive. My sister passed now, I passed. I'm the only one still alive. Now she has to reevaluate. So my question is, because she was worried about inheritance tax, we should just answer that question. So the other thing is because she's so worried about how to allocate things so that it actually goes to me, but I think what I understood that you're saying is, there was good news, I won't have to pay an exorbitant amount of tax, but then isn't it, inheritance tax is just for one time, right? It's not like they'll look at my assets every month from what mom left for me and take me to the claims, or yes or no? Because I think that's what she said.
Okay. So the direct answer to your question of when is inheritance tax assessed, that is a one-time deal. And it's a tax that's owed within a certain period of time from the date of someone's passing. Usually that is a tax return that's paid in the course of administering the estate, if there is an estate. You mentioned that your mom has a trust plan, and I don't want to give individualized legal advice because I don't know about that situation, but it's likely that the payment of any tax, if there is, would take place in the administration of that trust. If what's happening is your mom is leaving things directly to you, that's the trunk of the family tree, right? So there may not be a tax conversation to be had. She may be able to kind of breathe a sigh of relief and say, okay, I misunderstood that, but no.
We're coming down to just a few more minutes. I think we have time for one more question.
How important is it that I record my will?
The answer is if it's important to you, okay? So there are, it sounds a lot like it depends, right? There are three places that we typically recommend that people house them. One is a safe deposit box at a bank. I can't recommend that you go get a safe deposit box just to put your will in it. And sometimes it makes it more difficult because if you haven't given somebody else authority to go there and get it, they may not even know it's there, right? So that's not helpful. I keep mine in a little fireproof safe at home. I think I bought it at Staples a few years ago just so I would have one. I put some other stuff in there. Nothing exciting. My will's not exciting. It does what it needs to do, and it sits where it needs to sit. I'm okay with that. But the third option is to register it with the Register of Wills. It's easy to do that. They charge a whopping $5 to house it. They index it in a very private way. It doesn't make it a public document. And from a practical standpoint, that is where somebody is going to have to take it anyway if you were to pass. Right? You have to take the original last will and testament to the Register of Wills. So if it's already on file, you skip the step. It does make it easy. It doesn't make it public. So that's just as easy. We do that all the time. Yeah.
Just a curious question for you, Eric,
Yeah.
and I want to get my money's worth out of this. So have you ever had a situation, and this is just pure professional curiosity, where someone has the video and the grand reveal where everyone goes in your office and they find out how the
reading
millions
of
are
the
going to
will?
be? Yes.
Yeah. Did you watch like Dallas and Falcon Crest and stuff when you were a kid? Or
Of course.
just, yeah. Yeah, it doesn't usually happen that way. It doesn't usually happen that way. More
I'm
often,
shocked that the movies misled you
yeah,
there.
well, I wish being a lawyer was more exciting than that. But I will say this, though, that given the advent of just everything digital, it is more common that family members share their planning documents with each other. You know, that is there a reason why my daughters shouldn't see what my will says if all they're going to have is a photocopy and not the original? Then and knowing that I can change it any time that I want, I just find that people are sharing them more. One really good reason that happens is people keeping advanced medical directives on their cell phones. Right? If I get a call that my wife needs me at the hospital, I don't want to have to run home to the fireproof safe, get the thing, undo it, then go back. I'd rather just show up at the hospital and say, here, put this in your electronic medical record. So that is a roundabout answer to your question. But I've had it happen when there's conflict because everybody wants to be in the same room and read it together,
Right.
so that there's not a misreporting of, well, you said the will says X, Y, Z. Your colleague here had one question as well. Sorry.
We have wills with each other as beneficiaries and then our son. And then there's a level after that. But when do you have to have an executor? Does that have to come into play if one of us passes or it goes to my son?
Yes, the answer is yes. Anytime an estate is administered through the probate process, an executor will be appointed. Maryland's phrase for executor is personal representative. It's the same thing. And the fundamental thing that happens when an estate is opened is that an executor or personal representative is appointed. And they are given a magic permission slip called letters of administration to go forth and do everything that needs to come next in following the rules that are in the will.
If a spouse dies, you still have to go through.
If an estate is being administered, if you're opening an estate. So And I'm not being cute. There's a possibility that most all of the assets that a husband and wife own are owned jointly, right? That's a function of how things are titled. And if we go back to my rule of, does the asset already have rules that tell it where to go? Well, when husbands and wives own things, they both own 100% of it 100% of the time. So when one of them's gone, it already has rules that tell it where it lives. It doesn't need an estate to be opened. But if an estate gets opened for anyone, a personal representative will be appointed. If your will doesn't already instruct who that's going to be, Maryland law will appoint that person for them. Okay.
Eric, thank you so much.
My pleasure.
That was super, super helpful. Thank you. So we are at the end of our session. I hope I kept my promise that at least one takeaway that you found valuable in this presentation, if not many more, will help you improve your financial future. We looked at a lot of stuff. Markets, how to invest our money, downturns, long-term care costs. A lot of it is a little dry and it might be overwhelming. Don't worry. I would say our team is the best that I know of to help sort through the noise and just give you bullet points of what we do, and we keep refining it. But truth be told, there's many amazing financial advisors out there that have hearts of gold like us. We just want people to be informed and take action and improve their situation so that they can get more guac. If you're interested in having a conversation with us, it doesn't cost anything. We're not going to call you after this event and bug you. This isn't like a timeshare pitch thing. I think somebody asked before they signed up. That's not our style. But we're here. We're easy to find. You can register on the website, have a conversation. We'd be happy to help you. So with that, thank you everyone so much for coming. And we wish you all the very best and enjoy the rest of your weekend. Thank you.